Good afternoon, everybody. My name is Lynn Drake, and with me today I have Leslie Banas with Kemp Klein Law Firm. How are you, Leslie?
I'm great. How are you?
Good, thanks. Just a little bit of history about Leslie. Leslie provides real estate and corporate legal services to clients in the commercial real estate sector, multi-family housing, healthcare, technology, and professional service industries. Her real estate practice involves assisting real estate owners and operators in dealing with their office, warehouse, retail, and multi-family property assets. I don't know why I keep falling over that word. She helps them with development, repurposing activities, acquisitions, dispositions, and financing matters. She recently assisted Northville Township in its disposition of township-owned real estate for development purposes along the 5-mile corridor between Beck Road and Napier Roads. A substantial portion of Leslie's practice is devoted to representing landlords and tenants in commercial lease negotiations, office, and retail build-outs. In addition, she assists investors in the acquisition and disposition of net leased properties throughout the United States. I didn't even know that before I read this bio. Leslie is a frequent speaker and commentator on commercial real estate transactions and business topics. She is a shareholder and director at Kemp Klein Law Firm. She is listed in the Best Lawyers in America and Super Lawyers. She is a former chair of the Real Property Law section of the State Bar of Michigan. Leslie, thanks for joining us today.
I'm happy to be here.
So I just have to share this because I'm still chuckling. Leslie and I recorded this once before the day that Zoom died. So we are re-recording this, so it seems a little funny to re-record it, but that's what we're doing today. And just as a point of interest, the date that we are recording this is September 1st, 2020. And the reason I bring this up is some of the things that we're going to share with you today may not be the case in the future. But this is as it stands today, right?
The law always changes. That's
Exactly.
something I can count on. Thank goodness.
Keeps you employed, doesn't it?
That's why people need me.
Yeah, absolutely. And by the way, Leslie's a great attorney. I just want to put that plug in. Okay, so let's get started with the questions. Can you share with us what the attorney's role is in client purchase of commercial real estate or industrial properties?
So generally, my role is to advise the buyer with regard to legal and real estate matters and to help move the transaction to closing. And that involves helping to identify and negotiate the purchase terms and either to prepare or review the purchase agreement and the other documents to help the buyer with due diligence that he needs to perform and to review any of the materials that are collected. And based on my experience, to identify any issues that might impede the closing and try and craft reasonable solutions that are acceptable to both parties. And then I make sure that the closing and transfer of title and possession is completed consistently with the purchase agreement and in accordance with up-to-date commercial and legal standards.
All right, let's see. What steps do you take to assist the buyer as the transaction progresses? Because we know there's a lot of steps.
There are a lot of steps in a commercial real estate deal.
Yeah.
Usually by the time a client comes to me, the client's identified a property that he or she is interested in. And sometimes with help from people like you, Lynn, the brokers, he's obtained a response to his RFP, or he signed an LOI or a term sheet, which identifies some of the basic business terms of the transactions the parties have agreed to. So I like to start by having a pretty comprehensive discussion with the buyer as to what they like about the property, what their needs are, and otherwise what they're looking for. That helps me to get a sense of which things are going to be important in the transaction. And then I identify things that aren't usually covered in one of these preliminary documents or discussions, and discuss with my client how those items should be covered in the purchase document. And with that background in hand, I'll prepare the purchase agreement, or I'll review an agreement that's been prepared by the other party or their attorney. Once we've worked out any of the additional terms and provisions, and we've signed the purchase agreement, the buyer then moves on to the next step, and I go with. And that is the investigation part of the transaction, which is often called, in our parlance, due diligence. And that involves obtaining and reviewing title work, survey, doing a physical inspection, maybe an environmental review, and a review of other types of documents. At the same time as due diligence is going on, it's generally the case that we need to start and negotiate the mortgage loan if there is going to be mortgage financing for the transaction, and I help the buyer work out any of the terms and conditions necessary and review those documents. And then as time is going on, I'm monitoring whether or not any of the conditions to closing that we've identified in the purchase agreement are being satisfied, or if anything is outstanding. All along, as this time goes on, both the buyer and I have to be very conscious of the deadlines that are in the purchase agreement. We have to make sure that we complete all of the matters that we are responsible for within the contractual time period, so that we avoid default and so that we preserve our rights under the purchase agreement. And then as we get closer to closing, I'll review the closing documentation, like the deed, if there's a bill of sale because personal property is being transferred in, and if there are peripheral documents that are going to be part of the transaction, because, for instance, the seller is granting the buyer a separate easement, we will work on those transactional documents as well. Shortly before closing, we'll contact the escrow agent, because most closings these days are handled through an independent escrow agent, most frequently the title company that's issuing the title policy. And we'll submit materials to them and basically get them teed up for the closing process. Then once closing has been completed, we'll make sure that the right documents have been recorded to evidence the buyer's ownership of the property. And we'll typically send our client a closing docket that includes all of the closing materials so that they've got them in one place.
One thing I think I shared with you a story. I did a transaction last year, and the agent that brought the tenant or the buyer to the building was a residential agent with very little experience. And they used a residential purchase agreement with little or no changes to the document that should have been in there, like Estoppel certificates, inspection rights, and all these kind of things. They didn't have anything like that. And nor did they use an attorney, because the attorney would have never allowed that to be signed. And I think it's important. And as the story went on, they actually missed their dates. And every time they missed a date, their due diligence period was over. We charge them another $10,000 to deposit on the money to make sure that they're going to follow through. And now, if they'd had you on that, you wouldn't have let them sign that agreement, I'm assuming.
Nope. There are a lot of important differences between a residential real estate transaction and a commercial transaction. And purchase agreements are important. It's important to start with the right form.
Exactly. And I think, it's important too, if you're hiring somebody, you can use a residential agent as long as they've done more than one transaction or two or three. Because this was the first one. It was a disaster.
And it helps if the attorney has been involved, not just in commercial matters, but in the kinds of matters, the kind of real estate acquisition that the buyers embarked on. Because there are specific kinds of differences depending on what kind of a property you're purchasing.
Yeah, she's exactly right. And I think what I find is a lot of general attorneys do this. And there are some real specific things for each type of real estate. And I don't think that they're necessarily going to catch them if that's not what they do every day. We all have things that we're specialists in. And I think it's really important to get not only an attorney, but a real estate attorney that knows how to work in that area, because no one can be the be all end all to everybody. And I think that's what people don't realize. They think that all realtors or real estate agents are all the same, and they all have their specialties, and the attorneys are the same way. They all have their specialties. So it's really important to get someone like Leslie when you're doing a commercial purchase transaction or lease. She's helped me many times. Okay, let's see. How important is a comprehensive purchase agreement to the buyer?
Well, as we said, there are differences between residential purchase agreements, commercial purchase agreements, but the terms and conditions of a commercial purchase agreement are crucial to a buyer receiving the benefit of his or her bargain. It establishes like the contractual framework for the parties' deal. It gives you a clear roadmap to closing, and it covers a lot of the hot button issues that over time, historically, have caused disputes and angst between buyers and sellers. So a thoughtfully prepared purchase agreement that's tailor-made to the buyer's transaction will help the buyer obtain sufficient information to become fully informed about the property so he can make a knowledgeable purchase decision, and it will contain reasonable protections for the buyer. And to make sure that the buyer, who after all knows what he or she needs, to make sure that they get what they're expecting, the buyer really needs to be an active participant in the negotiation of the purchase agreement and the different terms and provisions of the purchase agreement. And it's, I have found in my experience that in some cases, buyers will sort of hold back the questions and concerns that they have about the property because they're concerned about getting the deal. And I completely understand that point of view. And there are certain cases in which that kind of strategy works.
Mm-hmm.
The problem is, once an agreement is executed, the other side, at least, is fully invested in the agreement as it appears in its four corners.
Right.
And it might be difficult to make changes down the road when there's a lot of deadline pressure involved. Mm-hmm. So in my view, most of the time, there are exceptions to everything, but most of the time, it's better to be proactive and to cover all of the known issues before execution, if you can.
Right. And, that's why as an agent, I don't do the contracts, but I do the letter of intent, and we try to capture all the items in there, but then it goes to the attorneys, and the attorneys work out the document. So if there's anything missed, they can capture it at that point, because then they haven't signed anything, basically. Well, they've signed the letter of intent, but it's subject to a purchase agreement being completed. So what are some critical provisions in a purchase agreement for a commercial property?
Well, the first one that sort of typically appears right at the beginning, after the identities of the parties and the date, is the property description. And in a lot of commercial transactions, we'll use, if we can, the legal description, or we'll provide for, if we don't have one, because it's a piece of property vacant piece that's being cut off from another piece, for instance, we'll provide that it's subject to a legal description to be provided in a survey. If there are certain benefits to the real estate ownership that are coming with this purchase transaction, like if there will be an assignment of an existing lease, we'll usually list that in the property description as well. As you and I have spoken before, to me, it's really important to correctly describe the property at points in the transaction so there's no misunderstanding. And let me give you one of my war stories. Several years ago, I was representing the buyer of a piece of property that had previously been used as a racetrack. It was a big parcel. At that point, we knew it was over 120 acres.
Wow.
The seller had owned the property for a long time, and they had very ancient title work and a very ancient survey with a legal description. And we included that in the purchase agreement. But because things were so vague, property had been a long-standing asset of the sellers, and because we wanted to make sure that we were acquiring everything the seller had, we included this phrase, besides the legal description, everything used by all property used by the seller in the operation of its business.
Mm-hmm.
Well, you know what happens. We went and engaged a surveyor, gave him the survey, asked him to draw property so that we would have an accurate survey. And when we saw the depiction on the survey, we saw that a piece of property on the corner, almost 2 acres, was not included in the legal description. That was kind of valuable to us, and the purchase agreement had been set. So we said to the seller, our deal is you sell us everything you own. So what we need to do is to rewrite the legal description so it includes those 2 acres. And based on our contract, the seller agreed. So the point of this story is it's important to have an accurate description of what's being sold in the purchase agreement to avoid issues in the future.
Right.
Another important set of terms are the financial terms. What's the purchase price? What's the deposit? Is there an additional deposit? Who holds it? When and under what circumstances does the buyer get its money back if the deal doesn't go forward?
Very critical.
Who's responsible to pay for some of the due diligence items like the title policy or the survey? What happens if there's a fire? Does the deal go forward? Does the buyer receive the insurance proceeds if he elects to close? Does he get any deductible from the seller? Who pays the escrow fees? All of these are important dollars and cents items, which taken together might be a very significant thing. So it's important to cover those clearly. The next important set of issues deals with time periods. How long does the due diligence period? When does the deposit become non-refundable? What's the seller's deadline to provide you with the title commitment? What's the buyer's deadline to identify any issues that are deal breakers for him? What's the physical inspection period? And what's the closing date? Another set of issues that's important to the buyer, what is the scope of due diligence? Is the buyer entitled to do a physical inspection? Is he entitled to do invasive testing, soil borings, environmental testing? What kinds of documentary materials is he entitled to get? Is he entitled to copies of prior environmental work? That might be of importance to him. What kinds of municipal approvals exist with regard to this property? And what additional approvals does the buyer need? And all of this is very important from the buyer's point of view because most often in these kinds of transactions, outside of specific reps and warranties, commercial transactions are on an as-is basis. So a buyer doesn't have much flexibility after a closing to go back against the seller if there are problems with the property that could have been disclosed or could have been identified during the due diligence period. Another set of important issues are the seller's reps and warranties. And those kinds of things are all over the board in commercial transactions. From the buyer's point of view, at a minimum, I would think that a seller should be willing and buyers should request representations from the seller on things that a buyer can't normally find out about itself. If sellers receive violation notices from the municipality because of the condition of the building or because of the location of certain improvements, that wouldn't necessarily show up on a title work that only deals with recorded documents. Is the seller aware of any proposed condemnation or taking? If a governmental entity like a road commission has filed a taking action in court, that's something a buyer could find out about. But if he's received a letter from the road commission offering a price prior to any kind of litigation being initiated, that wouldn't be part of the public record. And there would be no way that the buyer could find out about something like that. You also generally want the seller to represent that they themselves have not released any hazardous waste on the property, because that might have implications from a liability perspective to the buyer. And finally, another important set of terms deal with conditions to closing. And some of them are fairly simple. If a buyer needs mortgage financing, then there's going to be a financing contingency. There will be a period of time where the buyer can do its best to obtain financing. And if he's unsuccessful, then he's able to walk away from the deal and retain his deposit. We want to make sure sometimes that the property is in the same condition at closing as when the purchase agreement has been signed. Make sure that the seller hasn't let the property run down over that period of time, particularly if you've got a really long due diligence period. And that if, for instance, there haven't been any legal proceedings that have been initiated affecting the property, like condemnation, or for instance, that there hasn't been a termination of an underlying lease, if that income stream is important to the buyer.
That's a good list. I know in the book I'm writing, Do You Speak Purchase, I think I came up with 50 things to think about when you purchase. And
that sounds like a comprehensive list.
Because there's so much. I mean, that's the point that I don't think people get. And that's why you need an attorney to help, because it's their job to think outside of the box when they're looking at these things. So that was great sharing there. How about title commitment, title insurance? What can you tell us about that and why it's so important?
So title work is important to the buyer because at closing, in a typical commercial real estate transaction in our area, the buyer receives an owner's title policy, evidencing that the buyer owns title at the point in time when the deed is delivered to him. And that's a source of protection to the buyer. It's a contract of indemnity, so it's only true as of that moment, but that's generally sufficient for what the buyer needs. But that policy is subject to exceptions. And the categories of exceptions that are most frequently of importance to the buyer are things like security interests, like mortgages or construction liens, or rights granted to third parties over the property, like easements, or things like building and use restrictions. So these are important for the following reasons. And the title insurance commitment that the buyer receives during the due diligence period will contain a list of all of these exceptions so that the buyer can decide how important they are and whether they need to be modified, removed, etc. So mortgages and construction liens basically evidence the fact that the seller or some predecessor in interest owes another party money. The failure to pay that debt will result in foreclosure of the property and loss of title.
Mhm.
So it's imperative, if you've got a mortgage on property, that you're not assuming that you as the buyer make sure the seller pays off the mortgage, the construction lien, or similar kind of lien. Easements include things like rights of utilities to construct their utility lines, sewers over the property, rights of way in favor of governmental bodies, and sometimes access and parking easements. And those are the kinds of things a buyer really needs to carefully review so he can determine if the existence of those easements will affect his ability either to operate his property immediately or affect his ability to do changes or improvements to the property. If
Right.
you've got a utility line running diagonally from one end of the property to the other, it may be difficult for you to construct something below your building.
Mhm.
Maybe you can construct a parking lot, possibly, but you sure wouldn't be able to put in an outlot construct a fast food restaurant on an outlet lot unless that easement is rerouted. Similarly, building and use restrictions can affect your ability to operate your property or make changes, or even in certain cases make repairs, or sometimes modify the use of the property. And those building and use restrictions come up in a number of different ways. In some cases, if you've got a developer that starts out with a very large tract and then sells its pieces of it to others, the developer sometimes imposes building and use restrictions that provide for easements or certain kinds of setbacks or prohibit certain kinds of uses that would be detrimental to the other owners of the property. In certain cases, if a developer has difficulty obtaining approval from a municipality to build something and instigates litigation, the parties sometimes will resolve their differences and terminate any litigation the property owner has started by means of a consent judgment. That consent judgment typically also has conditions imposed by the municipality on what can be done with the property. Finally, you've got things like PUDs or other kinds of land development alternatives like condominiums that in their documentation may contain restrictions and conditions on the development of pieces of property. All of those things are important, and they may affect your ability to enjoy your property as a property owner to your maximum extent. So you need to be aware of them. And I do have an example.
Okay.
So a few years ago, I represented a nonprofit that had chosen a piece of property for its new headquarters. And it was a major acquisition, not so much of the land, but all the land development costs and the building costs for the vertical construction. But it was something that they had looked forward to doing for a number of years. When we received the title work, we found out, to our surprise, that the piece of property that was being sold by a developer was subject to a master deed. And this was one lot of a number of other lots. The condominium was a commercial condominium and clearly had not been successful because there were no other property owners. This would have been the first sale of a condominium unit. But the terms of the master deed were not favorable to us. They proposed a plan of creating various kinds of utility easements, entitled other property owners, the ones that would buy those units down the line, to install their utilities across our property and made us subject to paying various condominium expenses because we would have been the first owners, non-developer owners of the condominium. That was not acceptable to our client. And since this particular location was on a public right-of-way and very close to where utilities were already existing, saw no benefit in being part of this condominium to be formed, to exist in the future. And so we made a condition of the sale that our property be withdrawn from the condominium, and the developer agreed to that.
Oh, that's good.
And then the sale went forward.
Oh, that's creative.
Well, you have to do what you have to do.
I love that.
The truth is, it was hard to accomplish that.
Oh, I'm sure.
But the buyer was very committed to this parcel. It was a human services agency, and the public right-of-way nearby had bus access, which would have been very important for its clients. So we were invested in the property if we could get it under the right terms and conditions.
Right. Something else I want to bring up, you were just talking about zoning and all those things. I think doctors, I was just talking to a doctor about a space, and this happened to me 10 years ago actually. Was a doctor, and I was looking for sites for them, and they didn't understand that the building has to be zoned for medical. You can't just buy it or move into it. The client's like, you didn't do your due diligence. And I'm like, no, I did my due diligence. You can't go into that building. And I think a lot of people, the doctors are more likely to run into that, because why would they know that office and medical is different parking density? They probably would not. It's not a natural thing to think about. So those are the kind of things too that's really critical, that you understand, and you should be checking in with the city before you're putting some of these purchase agreements together, just to make sure that everything's copacetic. Can you share with us why it's important for the buyer to obtain a survey of the property?
Oh, yeah. So all kinds of interesting things show up on surveys. I generally recommend that a buyer obtain a survey of the property prepared by a registered land surveyor according to industry specifications. There is an industry standard for commercial real estate surveys through an organization called ALTA-NSPS, and the initials stand for something. It's a combined group of title companies that survey, professional surveyors. So it's important because it gives the buyer a pictorial depiction of the shape and the dimensions of the land and the location of the improvements. If it's detailed enough, it will tell you how many parking spaces there are on the property, so that you can tell if you satisfy your zoning requirements.
Yep.
And surveys in general, they reveal a lot of information about your property and the adjacent property. They show if your property encroaches onto another property or vice versa. It shows the location of easements that benefit third parties, which might affect your ability to make improvements or modifications. And it points out flaws in your title. So here are a couple of examples. In one transaction, I represented an industrial user that was interested in buying industrial property that had overhead doors in the back. And it would have been important for them to drive their trucks into the back so that they could unload and load various products. The building was set pretty far back from the main right-of-way, and there was a roadway that was to be used for truck traffic. We had the survey done, and lo and behold, it showed us that the roadway that we were relying on was partially on the property of the landowner to the north. So just at the point of the so-called turning radius,
Yeah.
part of that roadway was actually on the neighboring land. Well, that wouldn't have worked for our buyer. We didn't want to run the risk that at a point in time, the next door neighbor, who happened to be generally cooperative but could have sold his property at any time,
Right.
would not be cooperative. And so it was, required the buyer, the seller, to obtain an easement over the neighboring landowner's property to cover the roadway, which he did, and the transaction closed. In another transaction, we represented the buyer of a property that had a net leased drugstore. It had been developed by a developer that also owned the adjacent strip center that was next door. In looking, we saw that there were drainage easements over the property, our property. When we had the survey done, we saw that the drainage easement left our property and went onto the shopping center property into a drainage area. But there was no survey that specifically related to that drainage. So once again, we didn't want an issue to come up in the future whereby some successor to the developer decided to impose onerous restrictions on us or made us pay a lot of money to continue to use the drainage. So as a condition of that transaction, we required the developer to give us a specific easement for drainage on the shopping center property, which he was glad to do.
Yeah, so you never know. I think that's why I love real estate. There's so many things. Like I told you before, it's a puzzle, right?
Yep.
Okay. What are some critical matters for a buyer acquiring income-producing properties as an investment?
So a buyer that's buying net lease property is doing it because they are looking for a steady income stream. It is an investment play. They're not going to be using the property for their own business. Instead, they want a return. So it's important in that kind of transaction to focus on the matters that might reduce or stop the flow of funds. The first thing that's important to do is to carefully review the existing lease, because the landlord's rights to money arise from that lease. Yep, you need to understand how long the lease is, exactly what the tenant is obligated to pay, what the renewal options are, the termination rights, if there are other conditions like co-tenancy provisions that you mentioned before, Lynn, that might affect the ability to collect rent, and what the tenant's responsibility for operating expenses are. Conversely, whatever the tenant doesn't pay in terms of operating expenses or capital improvements, those become or continue to be an obligation of the landowner, the buyer. So the buyer needs to understand if it will be on his dime that things like the major operating systems within a building, like the HVAC, are to be replaced, or if it's his obligation to replace the roof or to replace the parking lot outside of just blacktopping it now and then. Another thing that's important is to obtain a tenant estoppel certificate so that the buyer is assured that the tenant agrees that the lease is in full force and effect and gives him information about what the tenant's view is of the tenant's financial obligations. And then I usually try and obtain a representation from the seller that the seller doesn't have knowledge of any information that might enable or permit the tenant to terminate the lease or to not renew the lease, or if it intends to assign the lease to another party, perhaps in a different business than its own. because that might affect the viability of the investment from the buyer's point of view.
Can you, for the audience, can you tell them what an Estoppel certificate is? Describe what it is.
Yes, good point. So you'll usually get a copy, if you're the buyer or the buyer's attorney, you'll get a copy of a lease agreement to review that has numerous kinds of, every kind of tournament provision that's important to a lease transaction. What you don't sometimes understand without other documentation is whether or not what the tenant's view of the lease is. And the Estoppel certificate is a signed document, generally contemporaneous with the transaction, that contains the tenant's information about the deal, confirming that the rental rate you think you're getting is indeed what they are paying, confirming what they think their operating expenses are, confirming that in their view, the landlord has satisfied all of the obligations it was supposed to satisfy. Like if there was a build out, that he completed the build out. Therefore, the tenant has no reason not to continue paying rent. And that's a step that in some cases, buyers seem to be reluctant to request. Sellers are sometimes reluctant to ask their tenants for the information. But that kind of real-time information and representation from the tenant certainly gives the buyer the comfort of knowing that once he closes on the transaction, that rental stream will continue the way he expects it to.
I was working on a transaction with a tenant this week, and the building sold, and the Estoppel certificates did not match. Now, sometimes it could be an error, and sometimes it's not. But you, as the buyer, you want to make sure, because that's basically the tenant saying, yes, this does match. Well, I agree with this, or no, it's not. So I told the client, you know, you need to change this and make the changes to the document, because you can't sign it this way, because that's not that's not what's expected. I think the other thing too is most leases, they require the tenant to provide, to sign off on these Estoppel certificates, and they're given a certain amount of time, and if they don't, they could be in default of their lease. I don't know if anybody actually kick them out for that, but hopefully they were smarter and they had like the right to sign it on their behalf. I don't know. I don't think I'd want that personally as a buyer, but gotta do it. There's so many moving parts. All right.
The last thing you want if you're the buyer of a net lease property is to buy a lawsuit with
Yes.
it. And this is one way to really flesh out whether or not there's a difference of opinion as to what the landlord's lease obligations are.
Exactly. I was told that it was really common in the retail industry to see that a separate letter agreement was signed for some particular reason. I've never really experienced it in that industry, but I'm sure that's true. Okay. What are some critical matters for a buyer acquiring an existing building to use for a buyer's own operations?
Well, this is where we get back to your doctor. If you've got a buyer that is going to use the property for his own business, then of course, fundamentally, it's important that the property can be used for that business. Yep. And you are right. There is sometimes a distinction in various zoning ordinances of different municipalities between a standard business use, small business use, medical use, and other kinds of office type businesses. Some of them deal with parking, as you noted, and some of them deal with other circumstances. So a buyer does need to know, first of all, that he can use it for its intended operations. There are a couple of ways of handling that. you can ask the municipality. You can ask the municipality formally to issue a zoning letter to you, and you can also obtain, in many circumstances, an endorsement of the title policy that at least identifies what type of zoning the property is part of. In addition to those kinds of legal requirements, you also want to make sure that functionally the building suits your purposes. And in order to do that, you need to actually do a careful property inspection, look at the configuration. If you're planning on buying an industrial building and using part of it for office space, make sure that the electricity is available in that part of the building and the other kinds of systems can be put in. And if they aren't there, get some kind of an idea of how much it's going to cost to fit it out for that kind of purpose. If you're buying property that, for instance, you're going to use for manufacturing or assembly, you want to make sure that the ceilings are high enough for your crane,
Right.
or your hoists. And if you've got heavy construction equipment, you want to make sure that the floor can bear the weight of your equipment,
Right.
without causing cracks in the concrete or problems that are even more severe.
Right. Yeah, on the industrial spaces, the floors come in all different depths. And if you have a super high ceiling, like 30 feet, and you're putting real heavy automotive parts, you want to make sure that that's a reinforced floor. And that's not always something that the tenant or the buyer might be thinking about when they're looking. And you've got to understand all of your requirements for everything that you do, because also the height of the room tells you how much you can stack and how much you can store in there. So then that's also critical too, that people sometimes forget to mention, or it might need to be all air conditioned. I had that happen recently. We're out on tour and it's like, oh, it needs to be air conditioned. I'm like, okay, these buildings are out, this building's in. So, okay.
So in addition to the building, one other thing, if you're going to be, for instance, parking a lot of equipment outside, you should make sure that there are no prohibitions that the municipality has imposed to that kind of outdoor parking over an extensive period of time, because it's really hard to move big trucks someplace else and bring them back every single day.
Right. Or they might not fit in if you don't have a high enough ceiling. You thought you're going to put them inside the building. If they're only 12 or 14 feet, they might not fit. I mean, there's a lot of things. You're right. I think it's important too for real estate agents to have some understanding of these zoning codes, because otherwise they're going to get themselves in big trouble, I think.
Yep. And the codes change, pretty frequently. And they do vary from one municipality to the other. So the fact that you are fairly confident, if you've got an existing building, if you're fairly confident as to what you can do in one municipality in Hazel Park, it doesn't mean that you will be able to do exactly the same thing in Clinton Township.
Exactly. Yes. Yeah. And I was looking at some zoning codes actually yesterday. And the city of Troy's are really easy to read. R1, this is what allowed. But this one, I couldn't even find them. I'm like, geez, oh, Pete, it's like a treasure hunt going through there to this other municipality, trying to find the zoning codes. But anyways, and then I called him and I got it over the phone.
Well, that's the easiest way to do it.
I know, but I like to look it up myself so I can see it. What are some critical issues for a buyer acquiring property for development or redevelopment?
If you found a location that's either vacant land or it's got a building on it that you're going to that's obsolete and that you need to redevelop or demolish and replace, then you as the buyer probably need a pretty generous due diligence period. Once again, as we've been discussing, you really need to become familiar with that municipality zoning ordinance and building codes to make sure that they permit your intended use, and that the density and the setback and the height and the parking ratios and the other construction and architectural limitations permit you to build or reconstruct a building that satisfies your needs. You also have to worry about some of the infrastructure improvements. Can you bring utilities to the site? Generally you can, but the costs of moving or installing a water line from a major intersection 150 feet across to the entrance to your property may turn out to be prohibitive. So it's good to understand what the requirements are and how much all of this is going to cost you, and whether you can obtain the approvals in a reasonable period of time. If people in the municipality are willing to work with you about these things, if you've got, if you're going to need turn lanes or curb cuts, and because of where the right-of-way is located, you're going to need approval from the county.
Right.
You should be prepared and get a sense of how long it's going to take for those various governmental entities to give you the approvals you need, because more likely than not, you don't really want to close on the property until you're fairly certain, like almost completely certain,
Yeah.
you can do what you want. It's not unusual in a development transaction like this to have conditions to closing that include things like your having received site plan approval, which is done once your architectural plans and conditions have been developed enough that the municipality is willing to provide you with the site plan approval, even a qualified site plan approval. And in certain cases, if you're going to need assistance from various kinds of government enhancements in order to make the deal a go for you, like for instance, qualifying for an abatement from property taxes under Michigan's Industrial Property Abatement Act, you want to make sure that you're pretty far along in the process before you actually pay the seller a lot of money for his land.
Yeah. Yeah, you don't want to make a mistake there. It'd be pretty costly if you didn't do your due diligence, right?
Right.
All right, and the last question, question number 10. What should be covered in the closing statement for a commercial purchase transaction?
So the purchase agreement will list the purchase price for the property, but almost invariably, the money that changes hands from the buyer to the seller is not in the specific amount of the purchase price. And that's because there are different credits and debits that apply to the purchase price. Some favor the seller and some favor the buyer. So one of the final documents that the parties sign at the closing is a closing statement that sort of apportions different expenses and benefit amounts to either the buyer or the seller. Property taxes, for instance, are usually prorated between the buyer and the seller based on the period for which the taxes are paid and the closing date. So if you are the buyer, you want to make sure that if the seller hasn't paid its property taxes, that there is a credit to you as the buyer for those taxes on the closing statement. Utilities and sewer costs are a traditional item to include in the closing statement. If the utilities are paid on the closing date, there won't be one. But if a bill comes after the fact, like for water or sewer charges, then you as the buyer want to make sure that money has been held back from the seller to cover those expenses, or that you've estimated it on some reasonable basis and can tap into money that covers that amount. Utility and sewer, water and sewer costs are in most municipalities exceptions to title. And so if they're not paid, they're going to affect the ownership of the buyer's property and will ultimately become a cost that the buyer has to pay.
Right.
So it's good to have some to deal with those unpaid amounts at the closing. And sometimes there are service contracts that apply to the property, and for good reason, a buyer may choose to take over an existing contract, like for snow removal or landscaping. And in that case, you want to apportion a bill that comes in after the closing to share the cost between the seller and buyer based on the closing date. And finally, if you're buying income producing property, you want to make sure that if the tenant has prepaid the rent, that you as the buyer collect a share of that rent for the period that you will be the owner of the property. So if you close on the 15th and the tenant has paid rent on the 1st, you as the buyer will be entitled to 15 or 16 days worth of rent, depending on how many days there are in the month of closing.
Great. That's great. Anything else that you just would like to share with us?
Well, I think it's exciting buying a piece of property.
It is.
Buyers that buy property are hopeful, they're entrepreneurial, they're generally buying it because they think it's a good business opportunity.
Mm-hmm.
And it can be, and it often is, but it's also a significant financial undertaking on a buyer's part.
Yep.
So you should always enter it thoughtfully and make sure that you've done as much work and invested time and effort in it to assure that it will be as successful as it possibly can be. That's my view.
Great, great. Well, thank you, Leslie. I really appreciate your time today. Can you share with the listeners how they might reach you if they'd like to hire you?
Oh, sure. So I'm a member of the Kemp Klein Law Firm, and you can reach me by email, leslie.banas@kkue.com, or by phone, 248-740-5669. And I'd be happy to talk.
Great, great. Well, I appreciate your time. Appreciate doing this twice.
I don't know. I think it was better the second time, Lynn. At least I hope so.
Anyways, I'm sure that the listeners are certainly going to enjoy this because you shared some really important things. And there are things that most people don't know unless they're working specifically in the real estate industry. So I appreciate it. Thank you. And I look forward to working with you again soon.
Nice talking to you, Lynn.
You too.